Some viewers may find the following video disturbing. Viewer discretion is advised.
Well, hello, and welcome back to the channel, everybody. Today's video takes us to Michigan once again, where we find Eric Martin, who's no stranger to Sovtard BS, and actually has a lawyer this time trying to get him out of jail. But of course, Eric Martin has to put his words in, and well, it doesn't seem to work out very well for him in this particular case. So, without further ado, let's go ahead and get this freaking S-show on the road, shall we?
All right, yeah, this is case 24-2448 SM People versus Eric Martin. And this is a scheduled pretrial conference on the charge of domestic violence.
Good afternoon, Your Honor. Nicholas Tarrant on behalf of Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could state your name for the record, please.
Capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N, family, a private living man, one of the sovereign people.
Of course you're a living man, dumbass. Otherwise you wouldn't be here. And I know you're talking about that Sovtard philosophy of the paperwork being the straw man and everything like that. And you're the living man who doesn't go through any of the consequences that the straw man has to go through. Am I right? And don't tell me that's not how it works, because I saw a video, well, a few videos of other Sovtards trying to get the paperwork to serve time for them.
All right, yeah, this is the pretrial conference. So are you Eric Martin, yes or no?
The living man has been known as by Eric Martin, yes, not the legal fiction corporate entity defendant, though. Spelled in all capital letters name.
Yeah, you're Eric Martin, in other words.
The living man has been known as Eric Martin, yes, not a legal fiction corporate entity, though.
Yeah, Mr. Dillon.
Your Honor, I was recently appointed to this case. The prosecutor just sent me the discovery. Mr. Martin has informed me that he filed a couple motions with the court. I haven't had a chance to review them, but in discussing them with them, one of them I'd be comfortable just asking the court. I think I can do it orally even. Mr. Martin has been incarcerated for about 38 days now, and under the applicable court rule, on a misdemeanor case, if he's been incarcerated for 28 consecutive days, he can be released on a personal recognizance bond. I think that that's appropriate in this case. The delay in this case was not any fault of his or anything like that. It's just he's unable to post the bond. So I would ask that his bond be changed to a personal recognizance bond from, I believe it's the $1,000 bond that he has to post. Additionally, I just, like I said, received all the discovery and whatnot. I would need an opportunity to review that. If Mr. Martin would be comfortable wanting to argue his own motions, I have no problem with that. But I have not had a chance to read them, and I would like to know, I wanted to be able to compare them accordingly to the police reports to see what they were. But I do know that just based off of what he told me, he's been incarcerated for, I believe my count was 38 days. Today will be the 39th day on a 93-day misdemeanor, which would allow for him to be released under the Michigan court rules.
Hello? Am I heard? No? Hello?
And so enters Kirk Martin, Eric Martin's brother and the victim in this whole escapade, as Eric has engaged in domestic abuse against his brother over here, and this is why he continues to end up in jail. One of the reasons, anyway. That's in addition to all his traffic violations and everything like that. Yeah, Eric is not exactly a good dude.
Yeah, do we have the prosecutor available on this matter?
He was just in here. I did tell him I would be raising this issue.
Okay. Yeah, I'd like to hear from the prosecutor on it.
He's in the main session now, Judge.
I'll go right and say what I got to say then, before the prosecutor gets a chance to say something.
So, this is on the Eric Martin case, charging as a misdemeanor domestic violence, originally placed on a personal bond. My understanding that he violated bond, and the bond was reset at 2,000 cash because he violated, I think, by having, I think it was, correct me if I'm wrong, contact with the victim.
Judge, Alex Winger for the people, P number PH6590. Judge, it's the people's understanding that the defendant cannot go to that address and went to that address, and he was then taken into custody because of that address that he went to, he's not allowed to go to.
So, Mr. Darren, you want to renew your argument about time period of being in custody on a misdemeanor case and why bond should be personal bond?
Yeah, Your Honor. I'll just briefly, as I did kind of let the prosecutor know, he's been incarcerated for, by my count, 38 days since December 17th when he was picked up. And he's now, it'll be 38 days, 39 after tonight. The court rule states that after 28 days, he can be released on a personal recognizance bond. There are most of the reasons that it would be denied is based on some sort of delay that's attributable to the defense. I know he's had a couple attorneys, but there's always been the court dates have been set. So I think he would be eligible for the release on the personal recognizance bond.
You have something to say, Your Honor?
Just 1 minute, Mr. Martin. We'll hear from the prosecutor.
Eric, you really should pay attention to what this man representing you just did. He followed the decorum of the court. He followed the procedures. He did everything he was supposed to do. He argued his point, and he moved on. And he let other people speak. And when he did speak, it was relevant to the case. Take note of that, Eric. That's what you should be doing when you represent yourself in a court, not the bullshit that you've been doing for the past few months. This is the example.
Yes, Judge, the people, the victim has been sending conversation talks to the victim advocate, and the people would ask if the defendant is released on a bond that the defendant would have a tether placed on the defendant, therefore that it can be rest assured that the defendant makes no contact with the complaining witness in this matter.
All right. Yeah, did you want to be heard, Mr. Burton?
Yes, okay, now, I want to add, under, not only before we get to the bond issue, the cases should be dismissed, which I did file a motion to dismiss already. The court probably just received it because I sent out not too long ago, like last week. Anyways, under MCR 6.004, subsection C 1 through 6 makes it clear that I have a speedy trial right within 28 days. Since I've been in jail illegally over 28 days, this case should be dismissed based on a violation of my speedy trial right. And based on the court rule I just named off, I'll say it again, case everyone heard clearly, MCR 6.004, subsection C 1 through 6, that is the criteria that is to be followed for speedy trial time computations, not the normal excluding Saturdays and Sundays and legal holidays. That's always been followed wrongly, but it's not, like I said, doesn't apply to speedy trial. So my right to speedy trial has been violated. The case should be dismissed.
But Eric, the only reason why you haven't had a speedy trial is because of your idiotic buffoonery. If you had just done the correct thing, this would have been over months ago. But guess what? Because of your dipshittery, it's going to come back to bite you in the ass later on in this video. So have fun.
So I want that decided on first before we address the bond issue. Because as long as that's granted like it should be, then the bond's no issue. But so once the decision's reached on the motion to dismiss, I just file it now. Then once the decision's on that, then I'll address the bond if it's not granted. But that's all I have to say on that for right now.
Now I've got a question for you, Eric. What would happen if you were released today? Where would you go? Oh yeah, it's been proven in the past that you would go straight to the place that you were not allowed to go, right to your brother's house. And this whole thing would start all over again, and because you just can't help being a complete and total douchebag. Let's face it. Your family hates you because of this garbage. Because you keep victimizing them every single time you get the chance.
Yeah, Mr. Rangel?
Yes, Judge, the defendant doesn't get the benefit of picking new counsel, and then when picking new counsel, reach a date where the case will then be dismissed. There's been, I believe this is the third or fourth defense counsel representing the defendant, and if it would be then in the court's client to dismiss this outright, then defendants would be able to set the ability to just keep picking new defense counsels, and once they get to 28 days, be able to argue that it wasn't a speedy trial and then have the matter dismissed. So it's the people's argument that the case should remain as charged, and addressing bond again, that if the defendant is released on personal bond, but on a tether.
I gotta talk to.
Okay, now, what he just said was, I was gonna say it's irrelevant nonsense. I've been in jail since the 14th of December. That's a fact, cannot be disputed. I've been in jail since the 14th of December is when I was arrested by Taylor Cops illegally, based on no evidence, based on my brother's lying allegation that I sold him, which is all it is, it's a lying allegation. But anyways, the fact is I've been in jail on the 14th till now. It's over 28 days. The court ruled again, MCR 6.004, subsection C 1 through 6 makes it clear when you are in jail consistently for 28 days, your right to speedy trial has been violated. It demands calls for the case to be dismissed. Simple as that. Everything else the prosecutor's saying is nonsense.
I'm in this video and I don't understand how I got put here.
Well, sir, you're not the only one that doesn't understand anything around here. But you can sit back, relax, and enjoy Eric Martin make a complete fool out of himself if you so desire. That is, if you have the time to do so.
All right, we're going to put you on mute, Mr. Kerr. This isn't your case at this time.
I'm supposed to be the defendant or the plaintiff or whatever. Hello?
All right.
Nobody even talked to me. Hello?
All right, so thank you. Yeah, who's speaking now?
That's the victim.
This is Kurt Martin, the brother.
All right, did you want to comment on this whole matter at this time, Mr. Martin?
No, I don't know. I couldn't even I didn't even know it was today, the court. I thought it was yesterday, and I was just called by the prosecutor that it's going on today. I've been hospitalized, and I'm now in a facility that's taking care of me, and so I don't have nothing really to comment about. I mean,
all right, very good.
I just want to make sure that you can see me and I was heard, because there's nobody that see me or something.
All right, well, thank you, Mr. Kurt Martin. So, all right, I'm denying the defendant's motion to dismiss based upon his changing of defense attorneys. The delays appear to be, to a great measure, caused by him by violating his bond conditions and repeatedly changing attorneys. That motion is denied.
Oh boy, your soft-hard tactics came back to bite you in the ass, and your motion was denied as a result of that. Congratulations, Eric. The 30-year law scholar, as he likes to proclaim, has failed once again. Congratulations, Eric. You're a total moron.
I will allow a personal bond in the case of $2,500 conditional upon a GPS tether and preventing the defendant from going within 1 mile of the victim's residence or having any contact with the victim, as well as no alcohol or illegal controlled substances, coming to court when required, advising the court of changes of address or telephone number, and not leaving the state without the consent of the court, not to possess any weapons and or firearms. And we'll give you another date for court. That'll be, we're gonna need an address for you or phone number, Mr. Eric Martin, for that hearing. Or you can come to the court and get that date. Come to the court and get that date, Mr. Eric.
I have objections to, can I talk now? I have objections to your order now. Can I make objections now to your order?
I did not hear that.
I said I have objections to your order. Now, first of all, in objection to your order, no delay has been attributed to me switching attorneys. That's false. Okay? I have not intentionally said, give me this attorney over that attorney. Whatever they did, that's what they did. You know what I mean? I told Slavin from the jump, yes, I want an attorney. Nothing is attributable to me. So the motion should have been granted, number one. Number two, even if you still don't grant the motion to dismiss like you're supposed to, I object to the bond condition. They violate my due process rights. I don't lose my due process right to be in my house I've been living at for 32 years. The house I've been living at for 32 years, regardless of whether it's mine or not, okay?
Do you understand?
Unsupported lies.
I understand your position, Mr. Martin. Are you telling me that you're unable to abide by my bond conditions?
That's right, because I have no other house to go to.
All right, Mr. Martin.
I have no other house to go to. And it violates my due process anyways.
Yes, so Mr. Martin is telling me preemptively he will not abide by those bond conditions. Therefore, I am going to change the bond back to the original bond and keep it at the cash bond because he poses a serious threat to the community. He's already demonstrated he won't comply with the bond conditions. And now he's preemptively telling me that he will not comply with the bond conditions I've just set. So therefore, your bond is remaining at what it was before, the cash bond. We will reset the pretrial conference and a notice will be sent out for that next pretrial conference. Same bond conditions. And
that violates my due process. I want to appeal this now. I want to appeal this to the Court of Appeals ASAP. It all violates my due process. It violates my...
All right, thank you. That's going to end the hearing.
We'll get the court date in the mail, Judge.
But here's the thing, Soft-Hard. Your due process was not violated. What was the issue was you dragging your feet thinking that it was going to help you out in the long run. Well, no, it didn't, because everybody knows what you were doing, constantly cycling through defense attorneys, trying to slow down the gears of the justice system for your benefit, so you could get the case dismissed. This judge saw right through that. And that's the problem with a lot of idiots like Eric Martin. They think they're the smartest people alive, but when it comes right down to it, they are often the dumbest people around. I mean, think of it this way, Eric. You claim to be a 30-year legal law scholar, but you have no actual experience within the field. And that's the problem right there. These judges and lawyers, they're out there every day dealing with this kind of stuff. they can see through your BS quite easily. And that was your ultimate failure here, because you had this belief that you were very well educated, while the people who actually do this thing every day for a living are total dumbasses. Well, no, it's the reverse that's the issue. You're the dumbass, they're the ones with experience. And with that being said, I hope you guys enjoyed the video. Thanks for watching, and I'll see you on the next one.
This could be some groundbreaking stuff right here.
You don't want to go to jail.
For what?
You read this.
I don't have to listen to anything. Blah, 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 blah.
Dude, so there's no way I can get in, bro? Come on, I'll put you on my YouTube.
But shut up, Wesley.
You gotta put signs up, ma'am, if it's...
Are you Glenn Serio?
Who's that?